In criminal law, the trial verdict is powerful, but it is not always final. Imagine a defendant convicted of fraud. The evidence seems strong, but weeks later, new facts emerge showing errors in the trial. Is the defendant without hope? Not necessarily. This is where appeals and post-conviction remedies become vital. They allow lawyers to challenge a conviction, argue procedural errors, seek a new trial, or even request remedies years after the judgment. Appeals protect against miscarriages of justice. They remind us that the legal system is not infallible and that every defendant has the right to be heard again. Today, we'll learn the language lawyers use in appellate courts and post-conviction proceedings, the vocabulary, the grammar, and the phrases that keep justice alive even after the verdict. Here's what today's lesson will give you. First, you'll strengthen your vocabulary for appeals and remedies, including appeal, appellate court, habeas corpus, miscarriage of justice, retrial, clemency, and amparo. Second, you'll practice advanced grammar structures used in appellate arguments, such as inversion for formality and conditional reasoning to test what might have happened if the law had been applied differently. Third, you'll master precise legal phrases like grounds of appeal, leave to appeal, sentence reduction, and extraordinary remedy. Finally, you'll apply all of this in real-world case scenarios from ordinary appeals to constitutional protections and post-conviction review. By the end of this class, you'll be able to discuss appeals and remedies in English with confidence and sound like a lawyer in appellate court. Let's begin with a story. A man is convicted of armed robbery after 2 witnesses identify him. He is sentenced to 10 years in prison. Months later, new evidence emerges, security footage proving he was in another city on the day of the crime. His lawyer files an appeal, arguing this is a clear miscarriage of justice. Now, the case shifts to the appellate court. The trial court has already spoken, but the appeal gives the defendant a second chance. The lawyer must argue, were errors made in the trial? Should new evidence be admitted? Does justice require a retrial or even an acquittal? But appeals, they are not automatic victories. The court could deny review, limit the issues, or even uphold the conviction despite the new evidence. If the appeal fails, the lawyer might turn to post-conviction remedies, a habeas corpus petition challenging unlawful detention, an amparo action in some jurisdictions to protect constitutional rights, or even a petition for clemency. This story shows why appeals and remedies matter. They are the legal system's safety net, tools to correct injustice, protect rights, and ensure the law serves truth rather than error. The foundation of this lesson is the word appeal. An appeal is when a party asks a higher court to review the decision of a lower court. It's not a new trial. It's a legal review of whether the trial was fair, lawful, and just. Imagine our wrongful conviction case. The defendant's lawyer believes the trial judge misapplied the law and excluded important evidence. Instead of giving up, the lawyer files an appeal. And why does this word matter so much for us? It's because the appeal is a lifeline. It can overturn a wrongful conviction, it can reduce a sentence, or it can clarify how the law should be interpreted. You'll hear professional collocations like file an appeal, grounds of appeal, which are the legal reasons for the appeal dismissed when the court refuses to change the decision. For lawyers, the word appeal carries more than just the idea of asking again. It represents the structure of justice, the idea that no single court has the last word. If an appeal is the request, the appellate court is the place where the request is heard. Unlike trial courts, appellate courts do not hear witnesses or re examine every fact. Instead, they focus on questions of law. Was the trial fair? Were the rules of evidence followed? Did the judge interpret the law correctly? And again, let's return to our wrongful conviction story. The defendant appeals, and the case moves to the appellate court. There, the judge reviews the trial transcript and the new video evidence. They conclude the trial court made serious errors. The appellate court overturns the conviction. Why is this so important for lawyers? Well, it's because appellate courts set precedents. Their rulings guide not only the case at hand, but also future cases. You'll hear sayings such as appellate court jurisdiction, appellate review of trial errors, or appellate court decision binding on lower courts. For lawyers, the appellate court is where arguments must be sharp, concise, and grounded in legal principles. Unlike trial courts where facts dominate, appellate courts are about persuasion through law. One of the oldest and most powerful legal remedies in criminal law is habeas corpus, Latin for "you shall have the body." A habeas petition does not argue innocence or guilt directly. Instead, it asks, is this detention lawful, for example? Imagine a man imprisoned after a trial full of errors, key evidence excluded, defense counsel asleep, or a biased judge. Even if appeals fails, he can file a habeas corpus petition. The court must bring him before a judge to review the legality of his detention. Why is habeas corpus important? It's because it protects the fundamental right to liberty. It prevents governments from locking people away without justification. You'll hear professional collocations such as file a habeas corpus petition, or writ of habeas corpus, or denied habeas relief. For lawyers, habeas corpus is a safeguard against abuse of power. It reminds the legal system that even after conviction, courts must answer a basic question: is this detention lawful? Sometimes an appellate court doesn't overturn a conviction outright. Instead, it orders a retrial. A retrial means the entire case goes back to a trial court, starting fresh, often with new evidence or corrected procedures. For example, imagine a murder case where the judge wrongly excluded DNA evidence that could support the defense. On appeal, the higher court rules. The original trial was flawed. We order a retrial. Now, the process begins again. Witnesses are called, evidence is examined, and a new verdict is reached. Why is this so important? Well, it's because a retrial can be both an opportunity and a risk. It gives the defense another chance to argue the case, but it also gives the prosecution another opportunity to present its evidence, sometimes more effectively than before. And you'll hear sayings such as order a retrial, grounds for retrial, or conviction overturned and retrial granted. For lawyers, the word retrial signals that justice demands a do-over, a recognition that the first attempt was not good enough to be final. Not every remedy comes from the courts. Sometimes relief comes from the executive branch in the form of clemency. Clemency is an act of mercy. It doesn't erase the conviction, but it can reduce the punishment. For example, imagine a prisoner sentenced to death. After years of appeals fail, the governor intervenes, granting clemency and changing the sentence to life in prison. Clemency may take different forms. It could be a pardon, erasing the punishment entirely, or it could be a commutation, which is just reducing the length or severity of the sentence, or it could be a reprieve, delaying the punishment, and this is often in capital cases. This is important because clemency sits at the intersection of law and politics. It is not guaranteed, but can be a final hope when all judicial remedies are exhausted. Common collocations are petition for clemency, executive clemency powers, clemency granted after international pressure. For lawyers, knowing how to request and argue for clemency is critical in high stakes criminal defenses. It reminds us that justice is not only about strict rules, but it can also be about discretion and mercy. In many Latin American countries, one of the most powerful post conviction tools is the amparo. Amparo is a constitutional action designed to protect fundamental rights when they are violated by government authorities, including in criminal convictions. For example, imagine a defendant convicted after a trial where the judge openly ignored due process. Even if appeals are denied, the defendant's lawyer can file an amparo, arguing that the conviction itself violates constitutional guarantees of fairness and justice. Why does this matter so much in legal English? Well, it's because amparo is not always directly translatable into other systems. In English, we explain it as a constitutional protection action, broader than habeas corpus and deeply rooted in Latin American legal traditions. You'll hear common collocations such as file an amparo petition, amparo remedy for constitutional violations, and amparo granted to overturn an unjust conviction. For lawyers, it's important to be able to explain amparo in clear English, which bridges civil law and common law traditions, showing an awareness of comparative remedies. Sometimes a post-conviction remedy doesn't erase guilt, but changes the punishment. This is where sentence reduction comes in. Imagine a man sentenced to 25 years for drug trafficking. On appeal, the court agrees the trial was fair, but finds the sentence too harsh compared to similar cases. The court orders a sentence reduction, lowering it to 15 years. Sentence reduction can happen through appeals, post-conviction motions, or even clemency. You'll hear common phrases such as petition for sentence reduction or reduction granted on appeal. Also, you will hear statutory limits on sentence reduction. For lawyers, sentence reduction is a realistic and often strategic remedy, especially when overturning the conviction itself is unlikely. It reflects a balance between justice and proportionality. In appellate law, not every mistake can be corrected by an ordinary appeal. That's when lawyers turn to an extraordinary remedy. Extraordinary remedies are legal tools reserved for exceptional cases, where normal appeals have failed but justice still demands review. For example, imagine a man imprisoned for years, and later it is discovered that the prosecution's star witness lied under oath. Regular appeals are finished. The defense petitions for an extraordinary remedy to vacate the conviction. This term is important for us because it captures remedies that go beyond standard appeals, like amparo in Latin America, habeas corpus, extraordinary review motions in civil law jurisdictions. You'll hear professional collocations such as petition for extraordinary remedy or extraordinary remedy granted to correct miscarriage of justice. Use of extraordinary remedies is limited to exceptional circumstances. This phrase helps you explain how legal systems balance finality with fairness, allowing courts to reopen cases only when the stakes are extraordinary. In appellate law, lawyers must sound precise, persuasive, and formal. One powerful way to achieve this in English is by using inversion structures. Inversion means changing the normal word order for emphasis. Instead of saying, if the trial court had admitted the evidence, you will say, had the trial court admitted the evidence. This structure is shorter, sharper, and more formal, perfect for appellate argument. Imagine a lawyer before an appellate court. Had the lower court followed procedure, this miscarriage of justice would not have occurred. The grammar itself emphasizes authority. Other common forms are, were the law interpreted differently, the conviction could not stand, or never before has the appellate court been faced with such errors. This matters for lawyers because appellate advocacy is about formality and persuasion. Inversion signals professionalism, the style of written judgments and high-level oral arguments. For advanced legal English, mastering inversion allows you to write and speak with the authority expected in appellate courts. In appeals, lawyers often argue not just about what happened, but about what would have happened if the trial had been fair. This is where conditional reasoning becomes a central tool. Consider a wrongful conviction case. The defense lawyer might argue, if the prosecution had disclosed the DNA report, the jury might have reached a different verdict. Or in a claim of ineffective assistance of counsel, had trial counsel presented the alibi witness, the outcome would likely have changed. Conditionals allow lawyers to build hypothetical scenarios that expose injustice. They say, this conviction cannot stand because under fair conditions, the result would have been different. This grammar is so powerful because appellate judges think in terms of what if? If the law had been applied correctly, if due process had been respected, or if the defendant had been represented effectively. Conditionals make those hypotheticals clear, logical, and persuasive. This skill transforms your arguments from factual description into structured reasoning that appellate courts expect. In appellate courts, every word must count. Lawyers can't simply retell the trial. They must highlight the most important legal errors. This is where emphatic structures give arguments weight and focus. Instead of saying the conviction should be reviewed, you can say it is essential that the conviction be reviewed. This adds urgency and authority. Or instead of saying due process was denied, you can say, what matters is that the defendant was denied due process. And for maximum precision, it was the trial court that misapplied the law, not the jury. These emphatic forms are subtle but powerful. They show the appellate court exactly where to focus on the legal error that undermines the conviction. And this matters because appellate advocacy is not about drama, it's about persuasion through clarity. Emphatic structures allow lawyers to stress constitutional principles, underscore unfair procedures, and direct the court's attention to decisive points. For advanced legal English, when you master emphasis, it helps you argue not just with facts, but with force, and the calm, authoritative tone appellate courts expect. In appellate law, you can't simply say, the trial was unfair. You must specify the grounds of appeal, the exact legal reasons why the verdict should be questioned. Imagine a defendant convicted of drug trafficking. His lawyer files an appeal. On what basis? The grounds might include improper jury instructions or exclusion of critical evidence, or even misconduct by the prosecution. Without clear grounds of appeal, the appellate court may dismiss the case without even reviewing it. Professional collocations include file grounds of appeal, strong grounds of appeal based on constitutional error, grounds dismissed as insufficient. For lawyers, this phrase is essential. It is the roadmap of appellate practice. The court does not retry the case. It reviews only the issues that have been properly raised as grounds of appeal. In many systems, filing an appeal is not automatic. You must first obtain leave to appeal, meaning formal permission from the court. Imagine a defendant convicted of fraud. The appellate court upholds the verdict. The defense now wants to take the case to the Supreme Court, but they cannot simply file another appeal. They must apply for leave to appeal, showing that the case raises important questions of law. This step prevents higher courts from being overwhelmed with weak or repetitive cases. Only appeals with strong legal merit or constitutional importance are granted leave. You'll hear professional collocations such as seek leave to appeal or leave to appeal refused and granted leave to appeal on constitutional grounds. For us lawyers, this phrase is vital because it frames strategy. Without leave, the appeal ends. With leave, the case may set a precedent. It teaches you that in appellate advocacy, not every battle is won by right. Sometimes it begins with permission. One of the strongest phrases an appellate court can use is miscarriage of justice. It signals that the trial was not just imperfect, but fundamentally unfair. Imagine a man sentenced to life for murder. Years later, DNA evidence proves someone else committed the crime. The appellate court reviews the case and concludes this was a miscarriage of justice. A miscarriage of justice can result from wrongful convictions, suppressed or fabricated evidence, judicial bias, or denial of constitutional rights. You'll hear collocations such as correcting a miscarriage of justice or grounds of appeal based on miscarriage of justice. Declared a conviction unsafe due to miscarriage of justice. For lawyers, this phrase is powerful and technical. It is not used lightly. To allege a miscarriage of justice is to claim that the entire trial was flawed and that the conviction cannot stand. In appellate advocacy, few phrases carry greater weight. In appellate law, there is a tension between two values: correcting injustice and ending litigation. The principle of finality of judgments protects the second. Imagine a defendant who has appealed 3 times, filed habeas corpus petitions, and even sought clemency. At some point, the court says, enough. The judgment is final. Why? Well, it's because endless review undermines stability. Courts, victims, and society all need closure. But here's the challenge. Finality of judgments cannot be absolute. If new DNA evidence proves innocence, should finality block review? Probably not. That's why systems balance finality with exceptions like amparo or habeas corpus. You'll hear collocations such as the principle of finality of judgments or undermined the finality of a criminal conviction, or balancing finality of judgments with justice. For lawyers, this phrase is key. It explains why appeals cannot continue forever, but also why extraordinary remedies exist in rare cases. It frames the debate between stability and fairness in post-conviction law. Let's put everything together with a real case-style narrative. A woman is convicted of fraud and sentenced to 12 years in prison. Her defense lawyer believes the trial judge wrongly excluded key financial documents. The first step is an appeal, filed on the grounds of appeal that the trial was procedurally unfair. The appellate court agrees in part, but upholds the conviction. The lawyer now seeks leave to appeal to the Supreme Court, arguing, had the trial court admitted the evidence, the outcome would have been different. The Supreme Court refuses leave. At this point, the conviction should have finality, but then new evidence appears. Email showing another employee committed the fraud. The defense files a habeas corpus petition, claiming the detention is unlawful. In parallel, because the country follows the Latin American legal tradition, the defense also files an amparo, arguing that the conviction violated constitutional rights to due process. This constitutional remedy keeps the case alive even after the courts try to close it. The appellate judges review the petitions and declare, "Never before has such a miscarriage of justice been presented to this court." Using emphatic structures, the lawyer drives the point home. What matters is that the defendant was denied a fair trial, and finally, the conviction is quashed. But the state still has the option of a retrial. After months of review, the prosecutor drops the case entirely. The defendant is free, not because the system was perfect, but because it provided multiple safeguards, appeals, constitutional remedies, and even the possibility of clemency. This story shows how advanced legal English connects with strategy. Appeals are not just technical procedures, they are the language of second chances, of balancing justice with finality. Let's review what we covered in this lesson. You expanded your vocabulary with essential appellate and post-conviction terms, from appeal and appellate court to habeas corpus, amparo, and finality of judgments. These are the words that let you explain remedies across different legal systems. You practice grammar that strengthens appellate argument, inversion for formality. Had the trial court admitted the evidence? You also practice conditionals for reasoning. If the defense had been heard, the result would have changed. And you learned emphatic structures for focus. What matters is that due process was denied. You also learned professional legal phrases like grounds of appeal, leave to appeal, miscarriage of justice, and finality of judgments, expressions that appellate judges use every day. Finally, through our case story, you saw how these tools come together in practice, lawyers balancing the need to correct injustice with the principle of legal certainty. This is advanced legal English at its core. Not just words, but strategy, clarity, and persuasion in the highest courts.